Thank you very much. Well, good afternoon. Welcome to the second meeting of the Senate Committee on Government Affairs. Thanks to everyone who is joining us online, and we welcome your participation. Members, please remember to mute your microphone when you are not speaking. And will the secretary please call the roll?
Vice Chair Orenshaw.
Present.
Senator Gocochea.
Here.
Senator Neal.
Here.
Senator Hansen.
Here.
Chair Don Daraloop.
Here. Thank you. All members are present, so we'll go ahead. And first, before we begin our agenda items, I want to briefly explain how our virtual meetings will work. I'll be giving this information for a few meetings here as we continue to have our community that joins us along the way virtually. As you know, the legislative building is currently closed to the public, and so all committee meetings will be held virtually, meaning committee members, staff, and everyone else will be participating through Zoom or by telephone. However, there are various ways for members of the public to engage with us and participate in the process. As in previous sessions, the committee-related information is available on Nellis, which is accessible from the legislature's website. There are 4 ways to engage with the committee. These include registering to participate in committee meeting through Nellis, which places you in line to testify on a bill or provide public comment, submitting written testimony to the committee email address or fax number listed on the agenda, sharing your opinion on the legislature's opinion application on Nellis, or viewing committee meetings online through Nellis or on the legislature's YouTube channel. During the 2021 legislative session, to testify on a bill or provide public comment, members of the public must first register for the meeting you would like to participate in. The committee meetings are listed in several places on Nellis, and you simply click on the participate button near the meeting date and time, fill out the required information, and you will receive an email with a phone number and meeting ID. Just to note that while meeting registration is required, it does not guarantee you will be able to speak. While you are on the phone line, please pay attention with which bill is being considered and follow the verbal prompts that the staff will give you, letting you know how to raise your hand and unmute yourself. Detailed instructions for participating in committee meetings are also available on the help page. If you need assistance with any of these processes, or if you'd like to receive electronic notification of the committee's agendas and minutes, please contact our committee manager at the committee email listed on the agenda. Meeting materials can be accessed on the committee's webpage on the Nevada Legislature website, and we'll have a period of public comment at the end of the meeting. Public comment and bill testimony will be limited to 2 minutes per speaker, and any additional public comment or testimony can be once again provided via written email. With that, we're going to jump right into some of our bills today. So we're going to open the hearing on Senate Bill 14. This measure revises provisions relating to certain emergency response plans and assessments. Will the bill presenter please proceed when ready?
Good afternoon, and thank you, Chair. Dave Fogerson, I'm the Chief of the Division of Emergency Management. I'd like to thank you for our ability to present to you Senate Bill 14. This bill draft cleans up some issues we found in utilizing the current language. First, it allows us to update how we provide a guide on developing an emergency response plan to those that we have to collect. The new proposal is to post it to our website and mail only upon request instead of mailing it to every entity required to submit a plan to our division. This will streamline our operations and eliminate some waste. The second change is to have our division work with the regulators from the Public Utility Commission, the Division of Environmental Protection, and the Office of Energy to compile the list of companies that should file their plans with our division. Right now, the definition of utilities is a little odd, and so working with these 3 groups, we've come up with some ideas on how we can move this forward better by working collaboratively together. We've met with these partners prior to the introduction of this bill to discuss how we can improve the intended outcome. This change is necessary to ensure we are receiving plans from companies that need to submit a plan. Under our current language utilities, companies that sell telephone cards must still submit an emergency plan even though they do not have the infrastructure in Nevada. By collaborating with our partners, we develop an effective list to meet the intent that emergency plans are held by our division for use should a significant event occur at the facility with critical infrastructure. We're open to any questions you may have regarding this bill. Thank you.
Thank you very much. Committee members, anyone have a question? Okay, quiet bunch today. All right. All right, well, no questions. Then we'll go to support on this bill.
Good afternoon. To testify in support of Bill SB 14, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 101, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Hello, this is Greg Lovato. I'm the administrator of the Nevada Division of Environmental Protection. I am just calling in to indicate our support for the bill. We're a coordinating agency, and that's it. Thanks.
If you have just recently joined us, we are testifying in support of SB 14. Please press star 9 now to take your place in the queue. Chair, we have no more callers in support at this time.
Thank you very much. We'll go to opposition.
To testify in opposition of Bill SB 14, please press star 9 now to take your place in the queue. Chair, we have no callers in opposition at this time.
Thank you, and we'll go to neutral.
To testify neutral on Bill SB 14, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 120, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good afternoon, Madam Chair, members of the committee. Stephen Cohen for the record. Stephen with a V, Cohen, C-O-H-E-N, as in the Assemblywoman, however, no known relation that we know of. Just real quick, want to, in light of this new COVID virtual world that we're all been living in the last 11 months, ensure that emergency responses, planning and assessment, take into account people with disabilities, that group of which is slowly growing as a result of the pandemic. With that, thank you, Madam Chair, and I yield.
Any additional neutral?
Madam Chair, there is no more callers in neutral at this time.
Thank you very much. I thank all of you. And Mr. Ferguson, do you have any additional comments on Senate Bill 14?
No, ma'am, just appreciate the committee's time to hear our request and appreciate any help and support.
Thank you very much. I appreciate your time. And I will close the hearing on Senate Bill 14. We will now go to Senate Bill 37. This measure revises certain provisions relating to the process by which a district attorney may request assistance in criminal cases from the Office of the Attorney General. Will the bill presenters please proceed when ready?
Good afternoon, Chair Dundera Luke, members of the committee. For the record, my name is Kyle George, and I'm the First Assistant Attorney General with the Office of the Nevada Attorney General. I'm joined by my colleague, Chief of Staff Jessica Adair, and Chief of our Investigation Division, William Scott. Under current law, before a district attorney can refer a matter to the Office of the Attorney General for investigation or prosecution, he or she must make a request to the county commission, and the county commission must adopt a resolution authorizing the DA to make such a referral. Historically, district attorneys have utilized this mechanism when there's either a real or perceived conflict of interest that would bar their office from investigating or prosecuting a matter. More rarely, district attorneys have also referred matters to our office when they lack the resources to investigate or prosecute a complex case. Unfortunately, because county commission meetings are public, placing a matter on a county commission agenda for referral to the AG's office also places the subject of the investigation on notice that he or she is being investigated. Any item that is sufficiently descriptive to comply with open meeting laws would also be necessarily sufficient to destroy the confidentiality of any active investigation. Additionally, if the conflict arises because the matter involves a county commissioner, the DA is put in the untenable position of going before the commission to discuss a legal issue with one of their own. This bill seeks to resolve the conflict and allow law enforcement to maintain the confidentiality of an investigation by permitting district attorneys to directly refer matters to the AG's office when they deem it necessary. The Office of the Attorney General is cognizant and mindful of county commissions' roles in managing their county budgets. And for that reason, this bill provides that the DA may only bypass the county commission approval process if the Attorney General's office informs the DA that it will not seek reimbursement for costs and expenses associated with the referred matter. We believe this solution respects the constitutional and statutory duties granted to both district attorneys and county commissions. The Office of the Attorney General has conferred with stakeholders, including district attorneys, public defenders, the ACLU, and the Nevada Association of Counties. And none of these stakeholders have articulated any concerns with this bill. We stand ready to answer all questions this committee may have on SB 37.
Thank you very much. Committee members, questions?
Madam Chair,
Yes, Senator Neal.
thank you. I have potentially two questions. So, Mr. George, I was wondering, so I looked up the history on this bill, and it dates back to, a version of this from 2011, dealing with the conflict of interest. And so what I was trying to gauge is, how have conflicts been handled if it involved the commission from 2011 till now? And what were the issues that popped up where it requires in 2020 for this to be changed?
Thank you, Senator. For the record, Kyle George, First Assistant Attorney General. Historically, the way that district attorneys' offices have dealt with this, the limitations imposed on them by the current structure, is they will call another DA's office. So, for example, when I was a prosecutor in Mineral County, we would call Churchill County if they had the resources available and say, hey, can you cover this for us? So it was a very ad hoc process when they wish to avoid county commission public discussion of the matter. You asked specifically about what precipitated this bill. In the past couple of years, we've had, I can think of two cases. Well, one particularly jumps out. A county commissioner's grandson in a rural county was accused of a crime, and the DA believed that because of the nature of the relationship with the county commission, it wouldn't be appropriate for that particular office to prosecute the case. And they wanted to refer it to us, but understood that going through the normal procedure of going to the county commission would mean that the county commission was ruling specifically on the county commissioner's grandchild. I hope that's responsive to your question.
Yeah, it is. Madam Chair, can I have a follow-up?
Absolutely.
So my second question was involving, so when I heard the explanation that it's like, as long as, I guess there won't be any reimbursement associated, I guess I wanted to understand, what was the constitutional provision that allows this nuance to occur, where if there is no reimbursement associated with it, we can bypass the commission? What's the constitutional rule?
Again, for the record, Kyle George for Assistant Attorney General. I believe the answer is that that's a statutory, not a constitutional parameter. Under the current statute, the process outlines going to the county commission before referring the matter to the Attorney General's office, and therefore it's wholly within the power of this body, your body, the legislature, to change that process to bypass this. Because the constitutional considerations that I was concerned about is the county commission's duty to manage the budget of the county. And therefore, we wanted to construct this mechanism, our proposed mechanism, in such a way that it did not impact the county's budget in any way.
And I thank you for that, because I knew it was statutory, but what I couldn't find was the historical intent on why we felt clearly it was for the budget, but I also felt like there was a public interest associated with the commission. And although, your example is that the grandson of a commissioner, the thing that popped into my mind was, what about the public interest of the other commissioners getting a little bit more detail, just to know what is going on and how that works, I guess, because it seemed like there was also a knowledge issue for the commissioners trying to understand what is going on in their own body.
Thank you, Senator. For the record, Kyle George. That's a good point, and I understand the perspective from which you're asking this question now. I will point out there's several different constitutional considerations here. The district attorney's offices have their own constitutional guidelines. They're constitutionally independent from the county commissioner, from the county commissions, I should say. The other problem is that the current construction we have puts different areas of the statute of Nevada's revised statutes in conflict with each other. There are laws that say it's a crime to reveal the existence of an active criminal investigation. So on one hand, we have a constraint against revealing the existence of an active criminal investigation, with the need to go and publicize it to get a referral to the Attorney General's office. And I think this kind of removes that conflict, that tension between different areas of the law. Sure.
If I may follow up, Chair. Jessica Adair for the record. Senator Neal, I completely understand the intent behind your question in terms of the public interest for both voters, residents of the commission or of the county and the county commissioners. If a county commissioner has committed crimes that those residents of the county should be aware of. By statute, we also, and by constitution, if our office files charges, those charges will be public. And that process has to be public, has to be conducted publicly. So the commissioners and anyone in the county would be aware of those charges and the resolution of that case.
Thank you, Madam Chair.
Thank you. Additional.
Senator Goycochea, please.
Senator Goycochea, please go ahead.
Thank you, Madam Chair. Just a couple of things I'm concerned about. What would happen if make sure I'm still unmuted. I'm just concerned about the way this reads. As long as the Attorney General was not going to seek reimbursement for the action, then clearly the district attorney can request the support. And if he wasn't going to seek reimbursement, then in fact he would not have to notify the Board of County Commissioners. My concern is what would happen if you had a district attorney that had a number of cases he didn't particularly want to hear. So he, in fact, is calling the AG's office every week and saying, well, I've got this case or this case that I don't want to, just because he don't want to do the work on it. The other side of it, as long as the AG's office doesn't request reimbursement, it looks to me like the AG's office would then have to go ahead and provide counsel in those cases.
Thank you, Senator, to the chair and through the chair to Senator Gocochea, Jessica Dare for the record. I would say that in the AG's office, we are busy enough as it is that we cannot accept cases that don't involve a conflict, real or perceived. We have our own statutory and constitutional obligations and we frankly have a limited team. However, we understand that there are cases in which DAs rightfully cannot prosecute those cases, but they are important for us to prosecute. So I would say that most AGs would not have the incentive to pick up the slack, if you will. And because all of these cases will be public if they come to a charge, I would say that the voters would ultimately hold that DA accountable. If a DA is shipping all of their cases to the AG's office, I think that they would probably have an earful from the voters. In our conversations with the DAs about this bill, we did not anticipate that they would be sending us many of their cases that they would otherwise not want to pursue. But they recognize that there are some cases that they cannot prosecute, but they really would like to refer to our office when it is appropriate.
Yes, I understand and I appreciate that, but we've had some really good DAs out there in rural Nevada that probably would love this bill. The other question I have is, what does the Board of County Commissioners, what would be their, how would they address then if it was the district attorney, in fact, that they wanted investigated or charges brought against?
Thank you, Senator Gocochea. For the record, Kyle George. Senator, I believe if the issue were in fact the district attorney itself, they could directly complain to our office and we would have jurisdiction under current law to directly investigate that DA. So this wouldn't implicate that in any way that I can foresee because we do have direct jurisdiction to investigate those matters.
All right, so in that case, the Board of County Commissioners would put the agenda out and it would let the district attorney know in that case then that he was going to be investigated. Yeah, I'm fine with it. It makes sense, but I do know some DAs in rural Nevada in the past that probably would have loved this because you would have got a call once a week until they took care of it. Thank you.
Thank you, Senator.
Thank you, Senator. Any additional committee questions? Senator Orenshaw.
Thank you, Chair Dondero Loop, and thank you for bringing this bill. Just a couple of questions. Under current law, under NRS 228.130, is the reimbursement usually waived by the Attorney General's office when they're requested to come in and assist Clark or County District Attorney? Just wondered if there's any data or anecdotal information as to what currently happens under the current statute as to reimbursement or not. And then on the example that was given about the county commissioner whose grandson was the subject and the district attorney sought assistance from the Attorney General, what happened there? Was it agendized on the county commission or on that county commission agenda? I just wondered if there's any information about that. Thank you.
Thank you. Through the chair to Senator Orenshaw, Jessica Adair for the record. I can answer the first part of your question regarding budget. I can tell you under AG Ford's administration, we have not sought any reimbursement from the county under the referrals that we have received. Frankly, the cases that we have not received have not been necessarily complex in nature, and we are fully capable of handling those cases under with our normal resources. Should a DA seek to refer a case that we felt like went beyond our existing resources, for example, an expert witness perhaps that would be extremely expensive for us, and we wouldn't have the budget to cover that. I think that would be an appropriate use of that reimbursement mechanism. But under AG Ford's administration, we have not sought reimbursement.
And Senator, for the record, Kyle George, First Assistant AG. To the second part of your question, the case I referenced, unfortunately, I don't recall how it played out. I know the suspect did a plea bargain at some point, but I don't remember jurisdictionally if it was through our office or through the DA's office. I have some recollection that the jurisdictional issue was resolved without obstacles that I discussed, but I don't recall how it was done. This was some time ago, unfortunately.
Thank you, Mr. George. Thank you, Ms. Adair. Thank you, Chair.
Thank you, Vice Chair. Any additional questions from the committee? Senator Hansen.
Thank you, Madam Chair. Just actually kind of a follow-up on what Senator Orenshaw was asking. I represent 7 counties, 6 rural ones. I'm just kind of curious, how often do you guys get these kind of calls? I mean, it sounds like they're fairly rare, but do you guys have any, it was 100 a year, and is there any counties where it seems to be a consistent problem, or is this just kind of a thing that they take advantage of only when they have, really severe criminal cases where they really need some expertise?
Thank you, Senator. For the record, Kyle George, First Assistant AG. That's a good question. I don't have hard data to answer that question. My gut instinct is probably about maybe a dozen a year, 10 to a dozen a year. I know when I was prosecuting in Monroe County, I was there 3.5 years. I probably had to deal with this 5 or 6 times total.
Oh, okay. I was getting the impression it's a pretty common thing.
No,
it is kind of funny because Senator Goycochea used to be County Commissioner Goycochea, and when he was County Commissioner Goycochea, my father-in-law was a district attorney for Eureka County, Alexis's dad. And so Pete, I hope when you're talking about a lazy DA, you're talking about Bud.
It was the guy that followed him was.
Okay. I won't go any more depth. Thank you, Madam Chair, for that indulgence.
We would never disparage somebody's family member publicly. Thank you very much. Well, Senator Hansen, you actually took one of my questions. I was going to ask you what the occurrence was, so thank you for asking that. Any additional questions from the committee on this bill? Okay. Well, if we've asked all our committee questions, we will go to hearing testimony in support. And please, testifiers, remember, just a reminder that it will be 2 minutes. Go ahead when you're ready, broadcasting.
Thank you. To testify in support of Bill SB 37, please press *9 now to take your place in the queue. Caller with the last 3 digits of 776. Please slowly spell and state your name for the record. You have 2 minutes and may begin. Caller with the last 3 digits of 776. Please slowly spell and state your name for the record. You have 2 minutes and may begin. Chair, we have no more callers in support at this time.
Thank you very much. We will go to opposition.
To testify in opposition of SB 37, please press *9 now to take your place in the queue. Chair, we have no callers in opposition at this time.
Thank you very much. We'll go to neutral.
To testify neutral on SB 37, please press star 9 now to take your place in the queue. Chair, we have no callers that are neutral at this time.
Thank you very much. Do you have any final remarks from the Attorney General's office?
Thank you, Madam Chair. For the record, Kyle George. While we were taking calls from the public, a member of our staff contacted us and advised that we get about 10 of these calls a month, these referrals a month, just in response to the questions previously posed on this. Wanted to supplement the record with that information. Thank you.
Just to clarify, that was 10 a month?
Yes, ma'am, that is correct.
Thank you very much. All right. Well, I appreciate your time and expertise today, and I'll close the hearing on Senate Bill 37. And now I will open the hearing on Senate Bill 38. This measure establishes provisions governing retention of pro bono legal assistance by the Office of the Attorney General. And you may go ahead when you're ready.
Thank you. Good afternoon, Madam Chair, members of the committee. I am still Kyle George, and I am still the First Assistant Attorney General, and I am still joined by Chief of Staff Jessica Adair and Chief of Investigations William Scott. Under current law, the Office of the Attorney General is granted exclusive authority to represent the state of Nevada on legal matters. There are carve-outs where the office may retain outside counsel on a contingency fee basis when, quote, the Attorney General lacks the resources, skills, or expertise to provide representation in a matter that is the subject of a contract, end quote, or to retain special counsel if representation by the Attorney General's office is impracticable or could constitute a conflict that precludes us from representation. Additionally, NRS 353.335 prohibits the Office of the Attorney General from accepting free legal services. The framework formed by these laws creates a unique loophole where the Attorney General's office may not, in fact, lack the resources, skill, or expertise to litigate a matter, but is unable to accept pro bono legal advice from top experts in the field whose guidance may greatly aid the state. This bill is intended to close that loophole by allowing the Office of the Attorney General to accept high-quality legal services or advice at no cost to Nevadan taxpayers. Before I walk through this bill, I would like to draw the committee's attention to a proposed amendment that we filed prior to this hearing. At the appropriate time, I will reference this amendment versus the original language of the bill. Section 6 is the first substantive section of this bill and provides explicit authority for the Attorney General to enter into a pro bono contract for legal services when he or she believes it is necessary. Section 7 provides that the Office of the Attorney General shall remain the ultimate decision maker on all aspects of litigation or matters on which pro bono counsel is retained. This provision preserves the constitutional role of the Attorney General as the ultimate determiner of what is in the best legal interest of the state. Section 8 merely provides that the Office of the Attorney General shall promulgate a form that must be included in all contracts issued pursuant to this bill. And Section 9 imposes an affirmative duty on pro bono law firms and attorneys retained pursuant to this bill to maintain billing records related to their work for a period of 4 years. These documents are public records. However, in the proposed amendment we filed, we have clarified our intent that the status of these documents as public records is not intended to compel the disclosure of otherwise legally privileged documents. Sections 10 and 11 are intended to provide transparency by requiring the office to, 1, post all pro bono contracts on our website within 5 days of final signature, and 2, provide annual pro bono activity reports to this legislature. Sections 12 through 14 are conforming changes. Section 15 of the bill amends the gift statute to explicitly provide the Office of the Attorney General may accept legal services provided on a pro bono basis by an attorney or law firm. The Office of the Attorney General is committed to bolstering public trust in our government. To maintain the integrity of our outside counsel statutes, our proposed amendments include a new Section 16 that provides that any law firm or attorney entering into a pro bono contract with the office is barred from entering into a contract as contingency or special counsel with our office for a period of 1 year after the completion of pro bono services. Thank you again for the committee's time, and we stand ready to answer any questions you may have.
Thank you very much. If the little cursor would just stay on the mute, unmute, it would help us all. Thank you very much. Any questions from the committee?
Yes, Madam Chair.
Senator Neal, please go ahead.
Thank you. So I had a question on, a couple of questions. Does this still require the approval of the governor? When I was looking at a bill that was similar to this from 2015, I believe it was Senator Brower's, and he had similar language, but it was dealing with contingency fee. I was wondering now with this insertion of pro bono, does it still walk the same pathway of approval of the board of the governor? And is it still considered quasi-prosecutorial?
Thank you, Senator, to the chair, and through you to Senator Neal. Jessica Adair for the record. To answer your question regarding Board of Examiners approval, no, it would not require Board of Examiners approval, and that's because there wouldn't be a dollar amount associated with the contract, which is a very different statutory requirement from contingency fee counsel or special counsel, where they would be paid for their services. And regarding quasi-prosecutorial, no, this would not apply to prosecutorial activities or criminal prosecutions. It would strictly be pro bono legal advice.
And Madam Chair, follow-up?
Please.
And I guess my concern was, although the Board of Examiners reviews things for a dollar amount, isn't there relationship to the AG a little bit stronger than just dollar amount? Isn't there some substance to their relationship as well?
Thank you, Senator Jessica Adair, for the record. No, I don't believe so. The Board of Examiners only approves contracts that is obligated by the state over a specific fiscal threshold. But to answer your question about a stronger relationship, the AG is a member of the Board of Examiners. So in that way, we do have a stronger relationship, and we provide legal counsel to the Board of Examiners. But the Board of Examiners typically does not approve any work that the AG's office performs, only contracts that the AG's office may enter into above a financial threshold.
And I guess, because you said that this, and I guess this is the issue that I'm having, right? I understand the whole pro bono piece of this, but based on all of the things, like I was listing out all of the things that the AG would oversee in this relationship with the pro bono contract. And it's more than just advice, because there wouldn't be this need of this intimate oversight if it was just advice, right? Yes, they don't get to agree, but for a settlement, but clearly they're negotiating a settlement, because it seems like, I guess, everything that's not said, like there's no reason to say that the AG has sole authority to agree to any settlement unless someone else is also negotiating on your behalf. And so I guess in my mind, I feel like, although this is unpaid work, it's still a pretty significant contract.
Thank you, Senator Jessica Adair, for the record. So the AG would retain all decision-making authority. The Board of Examiners normally does not approve any settlements that the AG's office enters into with any party. The Board of Examiners only approves contracts in which we enter into. The Board of Examiners does not have any oversight over the AG's office. I would say that in terms of these contracts or with pro bono counsel, the AG still has to maintain and enter into agreements within our constitutional and statutory authority. And the AG is the final say. And any counsel, whether pro bono, special counsel, contingency counsel, it does not have authorization to enter into any agreements without the explicit approval of the Attorney General. But thank you for asking that question, because I'm glad we were able to put that on the record.
Okay. Thank you for that. Madam Chair, I'm sure other people have questions. I had questions on Section 9, but I'll let other people go.
Okay, anybody else have a question? Senator Hansen.
Thanks, Madam Chair. Actually, one of them was already addressed. That is, this will not apply in any way, shape, or form to any kind of criminal proceedings. The next question is, I'm kind of wondering when. I mean, when do you need pro bono help? And does this apply only to individual lawyers, or would this apply to, for example, having the Attorney General get the American Civil Liberties Union to come in on something?
Thank you, Senator Jessica Adair, for the record. Regarding individual lawyers or organizations, any person or firm that we would enter into a pro bono contract with would have to be either a law firm or an attorney who is entitled to practice law, licensed to practice law. So a policy organization that is not licensed to practice law, they would not be considered, they would not be eligible for this kind of work. If, for example, the ACLU or any organization that has licensed attorneys working for them, I think they would be considered eligible for this kind of pro bono work. To your first question, in terms of when would this happen? So, for example, particularly when it comes to federal issues or very nuanced areas of law, there are attorneys who specialize in that work that may not be our bread and butter, but would be very happy and willing and able to assist us in those matters. So I will give an example, nuclear energy. So that we have outside counsel right now who are very specialized attorneys who are on retainer who assist our office under these normal special counsel statutory provisions. However, there are experts in the field who would love to assist us if we were able to enter into a contract. We can't, however, because of these statutory provisions. But more importantly, we have to have a scope of work that is agreed upon, written, has a beginning and end, to maintain that attorney-client or attorney-to-attorney confidentiality. So, for example, if in nuclear energy or any particular environmental lawsuit, we can't share privileged information that they might be able to, confidential information from our client with anyone outside of the office, unless there is a legal contract in place that would protect that information. So that's really a good example, I think, of what we're envisioning and why we would need this kind of contract.
Okay, so the Attorney General previously didn't have this kind of authority, so you were unable to access that in the past? I mean, is this something that is brand new? And the other quick question, how many staff attorneys are there actually in the Attorney General's office? 50, 100? I have no clue.
Thank you, Senator Jessica Adair, for the record. We have about 150, but we represent, and that includes prosecutors who wouldn't be, that's not what this statute is envisioning, but every agency in the state of Nevada and all occupational licensing boards. So it is quite a client and caseload here. But I think what we're really trying to get at is those specialized attorneys who would be able to assist us. And I apologize, I forget the first part of your question.
Previously, how did Attorney General offices handle this?
Yes, thank you, Senator Jessica Adair, for the record. They did not. They just simply did not accept that help. And if they did, that would have been illegal. So that would not have been, that would be frowned upon. So we haven't done that here in the AG's office. We had people reaching out to us saying, hey, I know about this area of law. Can I help you? And we said no, because we were not permitted to take them up on that. So how it's been handled, hopefully it has not.
Thank you, Madam Chair.
Madam Chair, may I supplement that answer as well, please?
Absolutely, please.
For the record, Kyle George, First Assistant Attorney General. The way our our office is currently structured, the majority of the civil litigation that takes place through our office is under me. And I can give you two specific examples where we may have deficiencies within our office. One would be antitrust, and the other would be bankruptcy. These are not things that we generally litigate in our office. These are not issues that will pop up regularly where our attorneys have the ability to develop experience over years. And they're both very arcane areas of law that require usually a tremendous amount of expertise. So right now we're in the position if it is necessary for us to litigate anything in that space, we are forced to either pay someone to do it through a special counsel contract or set up a contingency fee arrangement, which again involves us paying them. Whereas there might be experts who can just give us some quick guidance we need to get past that stumbling block, and we cannot lawfully do so at this time.
Thank you very much. Additional questions from the committee?
Yes, Madam Chair. I had a
Thank
question.
you, Senator Neal.
Thanks. Thank you, Madam Chair. So on section 9, and this is coming off of the amendment, I guess I was just trying to reconcile what's public versus work product. I know that certain facts can be on the public record as long as it's not associated with strategy. But I guess my question is, since there was an insertion of 239, what's left to be disclosed for inspection?
Thank you, Senator. For the record, Kyle George. I think there's still a lot left. So one example I'll back up. Legal strategy is in fact privileged. Legal theories that we explore is privileged. It's meant to promote frank discussion among attorneys and clients, so we understand the ramifications of any legal pathway we choose to follow. Billing records that are sufficiently detailed might actually reveal some of our legal contemplation. For example, a billing record that says research on the topic of ABC might expose that we are contemplating A, B, and C. So what I intended to preserve with the amendment, with the proposed amendment, is the ability to not compel attorneys to otherwise disclose privileged information in the interest of maintaining public records. So I want to make sure that we didn't go too far with the language of this bill, so that we're compelling the disclosure of otherwise privileged information.
Right. So thank you for that. So the question was, so what's left to be disclosed? Privilege is broad and it's wide. So in terms of, that's what I was trying to get at. Like for the public record, what is open for inspection under 239-010? That's the question.
Thank you, Senator Jessica Dare, for the record. So an important thing that would be disclosed is the fact that the charges would be zero. Another important thing that would be disclosed would be the firm and the attorneys working in that relationship. Another thing that would be disclosed would be the beginning and end date of the contract, and that would keep the AG's office accountable to the public to ensure that any pro bono counsel then wasn't later given a paid for contract within that year cooling off period after the completion of the contract, as well as I think a general scope of work. So we couldn't just say pro bono legal advice, for example. In order for the contract to be valid, it would have to be, the scope of work would have to be sufficient such that we would get into at least some detail about the topic of whatever that area of law would be. So assistance with Yucca Mountain licensing matters, things like that. So I think that, without getting into too much detail, there would be quite a bit left that would give the public and the legislators sufficient detail to ensure that the AG's office was going to be held accountable.
Thank you for that.
Okay, any additional questions? So I have one, and I think it's been answered, but I just need some clarification, not being of the legal field. So when you were talking about these experts, so if they're an expert in nuclear law, and then they come and they pro bono, they're retained to be a pro bono attorney, and then they go back and do nuclear law. So can you confirm or clarify that legal piece in there where they have the cooling off period? I'm not sure I quite understand that, because if that's the kind of law they're doing, it seems to me there would be an overlap and that would be difficult for them.
Thank you, Chair. Jessica Adair for the record. So the cooling off provision was really important after reviewing the bill and talking to stakeholders. We wanted to ensure that the public would have trust in the AG's office, that there wouldn't be any kind of quid pro quo, that if you gave us free legal advice here, we would give you a paid contract later. So we wanted to ensure that there was some provision in here to ensure that that quid pro quo, whether this AG or future AGs, would not be able to engage in. But in terms of your question about, what would be their business incentive, essentially, for giving pro bono legal advice to us? So already lawyers have to abide by ethical considerations that if they are working on for a particular client, they cannot engage for fee or for free in another case that might negatively impact their current client. So there's plenty of folks out there who would not be able to give us any advice because they're conflicted out. But if an attorney wanted to, out of the goodness of their heart, or because they particularly believe in a thing that the AG's office is trying to achieve, wanted to offer their advice, we would like to be able to take them up on that. So there will be plenty of attorneys who would not have an incentive, financial or otherwise, to engage in a pro bono contact with us. And that is perfectly fine. But if there are attorneys out there who would be willing and able to assist us on a nuanced legal matter, whether that's just being able to answer a few questions one day or a longer term contract, we would like to be able to take them up on that assistance, but to ensure with that cooling off period that there isn't the appearance of impropriety. I hope that is responsive to your question or provided a little bit more clarity.
Thank you. Thank you very much. Any additional questions from the committee? Okay, seeing none, thank you very much. And we will move to hearing testimony in support of Senate Bill 38. And just as a reminder, 2 minutes for each person. Go ahead, broadcasting, when you're ready.
Thank you. To testify in support of SB 38, please press *9 now to take your place in the queue. Chair, there are no callers in support at this time.
Thank you very much. Then we will move to opposition.
To testify in opposition of SB 38, please press *9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you very much. We will move to neutral.
To testify neutral on SB 38, please press *9 now to take your place in the queue. Caller with the last 3 digits of 120, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good afternoon, Madam Chair and members of the committee. Stephen Cohen for the record. Stephen with a V, Cohen, C-O-H-E-N, as previously identified. Just picking up real quick on Madam Chair's question at the end, and through you, I'm happy to work with the sponsors on this based on the last meeting. Is there anything existing or with this bill that in these special counsel situations would prevent either the special counsel from coming to work for the AG's office or the reciprocal situation. With that, thank you, Madam Chair, and I yield.
Thank you, Mr. Cohen, and I appreciate your thoughts. We do not respond to testimony, so in support, neutral, or opposition, so we appreciate your comments. Thank you very much. All right, with that, I will invite the sponsor back up if you have any closing comments.
Thank you, Madam Chair. For the record, Kyle George, no closing comments.
Okay, thank you very much, and we thank you for your time. And we will now close the hearing on Senate Bill 38, and we will open the hearing on Senate Bill 46. This measure revises certain provisions relating to the Office of the Attorney General. And presenters, when you're ready, please go ahead.
Thank you, Madam Chair, members of the committee. I hope you're not tired of me. For the record, this is Kyle George, First Assistant Attorney General. Once again, I'm joined by Chief of Staff Jessica Adair and Chief of Investigations William Scott Jr. SB 46 touches on several different statutes, but distilled to its essence, all provisions of this bill pertain to the safety of personnel in the Office of the Attorney General. Over the years, the Nevada Legislature has provided protections to numerous government officials whose personal safety may be at risk due to the nature of their service to the state. For example, judges, social workers, code enforcement officers, deputy district attorneys, and public defenders may take steps to keep their property and tax information confidential. But Attorney General staff is conspicuously absent from this list. Sections 1 through 4 of this bill allow Office of Attorney General lawyers to seal their property records with the county recorder and tax assessor, their voter records with the Secretary of State, and to display an alternate address on their driver's license. These protections are consistent with those currently extended to numerous other state and county employees, but not to Attorney General personnel. I would note that the language of these provisions applies to, quote, any person employed by the Office of the Attorney General who prosecutes or defends actions on behalf of the state of Nevada or any agency in the executive department of the state government. This construction is purposeful. Over the past year, state agents across the nation have been harassed, threatened, or doxxed for serving their states and communities. Here in Nevada, several officials were explicitly threatened. And in the Office of the Attorney General, DAGs from our Personnel Division, Criminal Division, Taxation Division, Public Safety Division, and Solicitor General's Office have all expressed concern at various points for their personal safety. Given the Attorney General's role as Nevada's lawyer, our attorneys become the focal point for the ire against the state itself. For this reason, our proposed bill language is not limited only to the Criminal Prosecutions Division. The last provision of this bill, Section 5, pertains to the sworn and badged officers of our Investigations Division. Under current law enforcement agencies, including sheriff's officers, DMV police, and the state fire marshal, are authorized to equip their vehicles with lights and sirens that readily identify them as law enforcement vehicles. The Office of the Attorney General is not on that list. As a result, the investigators of the AG's office often put in the position of arriving on scene in unmarked vehicles, routing or blocking traffic using vehicles with no obvious indicia of law enforcement while wearing badges and guns but no uniform. The likelihood of misidentification is high and unnecessarily increase the risk to both officers and the public during an encounter. Emergency lights on Attorney General vehicles would permit investigators to visibly convey their status as law enforcement officers from some distance and provide some safeguards against misidentification. Additionally, providing statutory authority for these peace officers to install lights and sirens on their vehicles will put them on equal footing with every other law enforcement agency in the state. Thank you again for the committee's time and efforts on this bill. We're happy to answer any questions you may have.
Thank you very much. Committee questions.
Yes, Madam Chair.
Senator Neal. I'm happy to have your questions, by the way. Thank you. Please go ahead.
I guess my concern is the first thing I circled, which is it's repeated in several parts, is or any agency in the executive department of the state government. We had this bill in Government Affairs in Assembly 2017, and that's when it added judges. And I remember bringing up the Attorney General because that was the time where I believe he was threatened and some strange person had jumped over his gate. However, it was, I don't believe it, I think he may have been added, but no one else. And then the bill died because I tried to add legislators because I was just like, why is everyone getting protection and saying that they're being threatened and the legislators are just stuck out there like we don't have that same capacity. So I'm confused on who are the any agency piece and why is it so broad to be inclusive? Because when you say any person, that's the secretary, that's everybody.
Thank you, Senator. For the record, Kyle George, First Assistant Attorney General. I just wanted to clarify that we are referring to any DAG, any Deputy Attorney General from our office that represents any state agency. We're not extending this to any state agency. This is limited to the DAGs in our office, just to be clear. The reason this is so, I'm sorry, Senator.
So, Mr. George, where it says any agency, that's the broad dumping to me of everybody. It's like a catch-all language to me.
Thank you, Senator. Kyle George, for the record. It should be read as who prosecutes or defends actions on behalf of any agency. So if you read the preparatory clause earlier in that sentence, you will see it is limited to those who prosecute or defend for the Attorney General's office.
Well, I guess the reason why I guess because it's an or. So I guess you could see it that way instead of an and, but I just thought every time I see any, I have a problem on who's included, and more so that legislators are not even being considered. That's my question. I don't have any other question.
Thank you, Senator. For the record, Kyle George. This language was supplied to us by LCB. I believe, and I think LCB does, but we'd be happy to revisit this in a markup process at some point. I believe that the construction of this is anyone who prosecutes or defends actions across two agencies, two descriptors, the state of Nevada or any agency in the executive branch. I believe that's where the or, what the or modifies. It's certainly an exercise of statutory interpretation, and we'd be happy to revisit that language and markup to make it more explicit that it is limited to the DAGs within our office, which unfortunately is the only jurisdiction that we have to propose bills at this time.
Thank you very much. Additional questions from the committee? Vice Chair, please go ahead.
Thank you, Chair Dondera Loop. And my question, if this passes with this language, would this apply only to the attorneys at the AG's office, or would it also apply to investigators who maybe have had contact with someone and that person might be, angry or have a grudge or something? And then that's my first question. And if Chair will indulge me in a second question, would this only apply to current members of the Attorney General's, or if somebody had retired, 5 years ago and is maybe concerned that someone they had prosecuted or something like that has a vendetta out for them, would they also be able to seek that protection?
You got it?
Thank you, Vice Chair. Jessica Adair for the record. So in terms of our investigators, would their information be confidential? So under the existing NRS, any peace officer or retired peace officer is already covered. So whether or not they're employed by the AG's office or a local law enforcement agency, they are covered. So in terms of retired, A retired peace officer, yes. I don't believe someone, the way it is currently written, who is a Deputy Attorney General for the AG's office who retires or goes to work elsewhere would be covered, because under the current language, it's a person employed by the Office of the Attorney General. I think that's similar to how in the statute, they treat folks who are social workers or work for the DA's office, et cetera. So we wanted to mirror that.
Thank you very much. Thank you. Appreciate it, Ms. Adair, Mr. George, and Chair. Maybe that's something that maybe looking at expanding that to folks who maybe didn't seek the protection, but now have left the office and have a concern. That might be perhaps something to think about. Maybe not now, maybe future sessions. Thank you.
Additional questions from the committee? Okay, seeing none, I just have one. Section 5, where you talk about the designated authorized emergency vehicle. How many emergency vehicles does the district attorney's office have currently? And I noticed there's no fiscal note. So would there be a fiscal note if we outfit those with those emergency lights and or sirens or any other emergency piece that needs to go on those?
Thank you, Chair. Jessica Adair for the record. Currently, we have 50 vehicles already authorized or already approved by the legislature. We use fleet services vehicles, and no, there is no fiscal impact. We are able to procure lights and sirens through some other fiscal means, namely forfeiture funding, but we don't have the statutory authorization to do so. So before we go make those purchases, we want to ensure we have the statutory authorization, and those the fleet services vehicles that we do have, you can incorporate lights and sirens into those vehicles without a large or extensive retrofitting. That would be different than we are not asking for painting the vehicles to indicate those vehicles are with the Attorney General's office, just the lights and sirens, and we believe that is sufficient.
Okay, thank you very much. That clarifies that. Any additional questions? One more last round from the committee.
Just,
okay.
Madam,
Yes,
Madam
Senator
Chair,
Neal, go ahead, please.
Yeah, just really quick, because when I guess I mean, because you're on finance, so I guess you're going to see this forfeiture request, use the forfeiture funds to buy this. So I guess this is I just want to make sure, like, is this the cart before the horse, or has that already been that's going to be presented at some point as a companion piece? The request to use forfeiture funds to put the sirens on the vehicles.
Thank you, Senator Jessica Adair, for the record. We could use forfeiture funds, or we could use existing funding. So lights and sirens are really not that expensive. But no, we don't believe that there will be a companion piece. If there is a companion work program, it will just be authorization for us to use the funding for us that's available, like we use forfeiture funds for bulletproof vests, other PPE that we use in order for our investigators to do their job safely. But no, we don't believe that any taxpayer dollars would be necessary for this. And thus, I believe we have not submitted a fiscal note for this.
Thank you. Thanks, Madam Chair.
You're welcome. And just as a follow-up to Senator Neal's question, while I recognize there's no fiscal note and that you could use forfeiture funds, I guess I agree a little bit that we do this, and then if for some reason there isn't funding somewhere, it just wouldn't happen.
Thank you, Chair. Jessica Adair for the record. So that's where we're operating currently. that we don't have the statutory authorization, so we haven't asked for any funding for that. We do have funds available for our office to use for safety of our officers, training, PPE, ballistic equipment, etc. Whether that's forfeiture funding or other funds, depending on the budget code in which our investigators are employed by. So not all are general funds, some are funded by assessments through various industries in which they are dedicated to investigating those particular crimes. So I don't want to get too far into the weeds, as we have about 22 different budget accounts. But the important piece that we want to bring to you in front of this policy committee is that we don't have this statutory authorization, and it presents a situation that is extremely unsafe. If someone drives up behind my car in my driveway, gets out of their vehicle that's unmarked, does not have any lights and sirens, and says, "You are under arrest," I don't have any indication to me that that person is a peace officer. So I may make a decision to resist what I don't know is a lawful arrest, or even worse, pull my weapon because I believe someone is trying to commit a crime and directed at me. So that is unsafe for both civilians and for our peace officers. So that's the important piece that we wanted to bring here today, is that statutory authorization. But if you have fiscal questions, I'm happy to get back to you in terms of the fiscal impact of this bill. So I know we're not in front of a money committee right now, but if you have specific questions, I'm happy to get you that data.
Thank you very much. And I very much appreciate what you're saying and the reason for this bill. I just didn't want to pass a policy and then you not have the funding to actually follow through with anything that's here. So I appreciate your time and explaining that to me. With that being said, I see no more questions. So we will go to testifying in support. Reminder, you have 2 minutes, and broadcasting, please go ahead when you're ready.
Thank you so much. To testify in support of SB 46, please press *9 now to take your place in the queue. Chair, there are no callers in support at this time.
Thank you very much. Please go to opposition.
To testify in opposition of SB 46, please press *9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you. We can go to neutral.
Caller with the last 3 digits of 120, please slowly state your name for the record. You have 2 minutes and may begin.
Good afternoon, Madam Chair, members of the committee. Stephen Cohen for the record. As previously identified, I concur with the concerns raised by the initially inquiring senators. With that, thank you, Madam Chair. I yield.
Thank you very much.
Chair, you have no more callers at this time.
Thank you very much. And with that being said, I'll ask the Attorney General's office if you have any other comments.
Thank you, Madam Chair, members of the committee. Kyle George for the record. No additional comments. Thank you so much for your time this afternoon.
Thank you for yours, and thank you for your service. We will now close the hearing on Senate Bill 46, and we will move on to our period of public comment. We'll pause for just a minute to give members of the public a chance to call in. Remember to clearly state and spell your name. Limit your comments to 2 minutes. We'll time each speaker to make sure everyone has a fair opportunity. You may also submit your public comments in writing. And public broadcasting, when you're ready, please go ahead.
Testify. Please press star 9 now to take your place in the queue. Chair, there are no callers at this time.
Thank you very much. All right. Well, with that being said, hearing no more public comment, we will conclude our meeting for today. Our next meeting will be Wednesday, February 10th at 3:30. And with that, the meeting is adjourned.
Madam Chair, whoa, hold it.
Whoa. Okay, Senator.
I'm sorry. Hey, I want to do one thing really quickly. Sorry, I should have tipped you off a little earlier. In our first meeting, we had the state treasurer and we had a little conversation about a bill that was passed back in 2011. After the meeting, the Gaming Control Board folks got a hold of me. This actually has to do with, back then it was Chairman William Horn, and Chairman Horn passed that bill back in 2011, took effect in 2013. And thanks to Chairman Horn's efforts, we have raised $72 million from the unredeemed slot machine wagering voucher. So just wanted to give a little shout out to William for really something that didn't raise any taxes, but has been averaging over $10 million a year. And the state treasurer wasn't aware of it apparently, but I thought that's something that we should really point out because, we'll all see William and he's still lobbying. But to have a bill that brought $72 million and still bringing in the money is really quite an accomplishment. So I want to make sure we got that on the record. Thanks for my interruption.
Absolutely. Thank you very much, Senator Hansen. We hope that's what all good legislators do is look out for our state. And I appreciate your time pointing that out. And I'm sure former Assemblyman and former Majority Leader William Horn will appreciate your comments as well. So thank you very much for ending our meeting on a positive note. And we will see you all on Wednesday if there's no more discussion. Thank you very much. This meeting is adjourned.